think may or may not be relevant. I put my facts in alternating colors so that they will stand out. And so that's what it looks like at first. That's just my first read. And then at some point, I come in and I start to put my rules in green. At some point, all of these rules are not going to be the rules that are relevant to the resolution of this problem. Okay? So then I need to go back in and start to determine what is it that is really the rule that the court is really using to resolve this problem. Okay? And so for us to be able to determine problems, we have to be able to develop an issue that will solve the problem. Okay, so if I get a whole lot of different case briefs in a contracts case that have an issue statement that says whether the defendant breached the contract, that's going to be the same issue for every contracts case. It's not going to solve the problem here. Whether the contract was enforceable, that's not going to solve the problem here. So that is what we have to do. We have to move ourselves into being able to develop a proper issue statement. Being able to problem solve is going to be that skill that is going to help us to be successful in law school. It's going to help us to be successful on the bar examination, and it's going to help us to be successful lawyers. I use the same analysis skills now. When I get a problem, first thing I do, I go in. And so once I determine what rule is really the rule that is that's surrounding the solving of the problem for the court here, then I start to zero in on that rule. That is the rule that is going to be used to develop my issue statement. Okay? So what really was the problem here in this case? Anybody? Yes, sir.
There was an addendum that
it seemed like an addendum.
They signed the contract, the Eurice or Eurice brothers signed the contract that made reference to that 5 pages, and they said that they had never.
Okay. All right. We're going to come back to that. But so then what the court determined is what? After this came back down from the, this came up to the appellate court. The appellate court determined that the lower court did not use the proper analysis. Why? Yes, ma'am. Right. The lower court just left it at, it was good enough for the lower court. Somebody made a mistake. But to solve the problem here, you have to determine, is it a unilateral mistake or if it's a mutual mistake? That's really the crux of the problem. Okay? And so when I start to determine that, then my rule is right here. So you start out broadly. The court says, the law is clear that absent fraud, duress, or a mutual mistake, that one having the capacity to understand a written document who reads it, signs it, or without reading it, or having read it to him, signs it, he's going to be bound by that. So the court says, okay, so let me go back here and see. What did I have? Did I have any fraud? Nope. I didn't have any duress. Nobody held him down and made him do it. And so the court says, well, in my mind, the thing that we need to determine is whether there is a mutual mistake or not. So this is where the issue begins to formulate around. Now, some of the case briefs that I got did not have an issue statement at all. So you have to even, because we're not going to be briefing any cases. Okay. This is just another class that deals with the skill of analysis. In your other classes, your brief cases, we're all teaching you subjects, using subjects to teach you analysis. Okay, that is the most important thing that we need to be doing here. So I am hoping that if you're briefing cases in your other classes, you have to formulate an issue statement for each one of those cases that you're briefing. And so now that I have focused on the rule now that the court is using, I'm going to use that rule. I'm going to use that rule. I put mine on a chart. I know, I get charts for everything, but I put mine on a chart. I put my issue statement up at the top. And it has to be something, it may be a lot of words. I could fix it later. But I gotta work on it first. Whether the defendant's mistake is submitting a 3-page agreement to the plaintiffs for signature and thereafter signing the final draft of the agreement that specifically indicated that it was subject to a 7-page document and a 5-page document without then reading it constituted a mutual mistake, which would mean there's no assent. That will result in a lack of a meeting of the minds, because that's what that's all about, mutual assent. Then excusing the defendants from their obligation under the contract, or was it a unilateral mistake? Which means there is assent at that point. In this court's analysis, if you just made a mistake on your own because of your own folly, then the court is going to say that there is assent, mutual assent. The other party should not be held responsible for your unilateral mistake. And so then the court goes into an analysis of how you determine that. And so then if you have a lot of or what I saw was a lot of, you have just like a paragraph of facts, I don't see how you can isolate any of those facts, how they would stand out to you when it's time to talk about it in class. And so this is, that's my issue statement. Now, I don't need all of this. I'm putting a lot of this here to explain to you why, whether it's a mutual mistake, this is what that means, or unilateral. You may not need all of this, but now I have my issue statement. Is it a mutual mistake, no assent, or a unilateral mistake, which means there's assent. So I'm gonna put that up in my top part of my chart. Then I'm going to take the left side of my chart and I'm going to put my rule over on the left side over here. Now see, the first part of that, I'm just, that's a part of the rule here, but it's not the part that's going to be used for the analysis, but I'm just going to put it up there just so I can have it in my mind. Okay, and so then the court defines what a unilateral mistake is. And so I'm going to use that to do my analysis now, so that I can test this thing and see if it's a unilateral mistake. If not, then that means it's a mutual mistake. And so then, now that I have done my first read of that contract, now I have my definition of a unilateral mistake. Now I'm going to go back and I'm looking for facts that are only relevant to the resolution of this problem. All of that stuff, I don't need to waste my time with.